try to quickly answer that question. I don't believe we're in a situation of non-compliance. We are in a situation of interpretation of the rules, and I think that is where the minister has highlighted that we're going to be updating the directive on privacy impact assessments in order to be more specific, to clarify, and will make it better in terms of understanding when a PIA is actually required.
Okay, thank you.
Thank you, Mr. Baines. Mr. Rochon, Minister, I want to thank you for appearing before committee today. We are going to suspend for a couple of minutes so that we can prepare for the next panel. The meeting is suspended for a couple of minutes. Thank you. hour. I'd like to welcome now, as an individual, Mr. Marion Dion, former Conflict of Interest and Ethics Commissioner. Welcome back, sir. And also from the Office of the Conflict of Interest and Ethics Commissioner, Mr. Conrad von Fickenstein, who is the Commissioner. Before we go to opening statements, I have been asked by Monsieur Villemure for a few minutes near the end to discuss something. So I'm going to make sure that we grant that time, and it's regarding the social media study, Monsieur Villemure. So, okay, merci. Mr. Dion, if you want to start, please, for 5 minutes, go ahead.
In fact, Mr. Chair, we will be saving some time because I did indicate to the clerk this morning that I did not have any opening remarks, so I will stop right there.
You always impress me, Mr. Dion, with your succinctness. Appreciate that. Sir, Mr. Commissioner, do you have anything you'd like to add?
Yeah, thank you. I'll be equally succinct. Thank you for inviting me to today. I'll gladly answer your questions regarding any aspect of our work. Vous comprenez que je n'étais pas dans mon poste actuel.
You would understand that I was not in this position when this report was published, and I have no comment to make regarding this report.
Aquilino, at the request of Mr. Dion, so that he can help him recollect some facts which after 5 years may not be necessarily in the mind of Mario right away. So that's all I have to say. Thank you.
Okay, thank you, Mr. Commissioner. We are going to start our first of 6-minute rounds with Mr. Barrett. Go ahead, sir.
I'll just start by saying, Commissioner von Finkenstein, congratulations on your appointment as our commissioner. That's new since your last, but one of your frequent appearances in the time between you taking on the interim role and today. So congratulations on that appointment, and thank you for taking on the role. It's incredibly important. Canadians value the work that's done to ensure that the highest ethical standard is maintained. I'm going to start with you, Mr. Dion. Thank you for joining us today, sir. My question is, of course, about the Trudeau II report. How many people did you interview, and how many people made submissions to you?
I have, at the end of the report on the last page, Michael is finding the page. If I recall correctly, we had 22 people we contacted for documents, and we interviewed 7 out of memory.
So of the 22 you interviewed, 7, would those 7 have been then the top of your list? Is that how you'd characterize that?
It's in the public domain, Mr. Chair. So we did interview former Minister Morneau, former Minister Wilson-Raybould, Mathieu Bouchard was a senior advisor to the PM, Nathalie Drouin, Deputy Minister of Justice, Elder Marquez, senior advisor to the PM, and Michael Warnick, who was with you 2 days ago. The other people with whom we communicated we were satisfied that the documents they had forwarded were sufficient for us to understand their participation in the subject matter without having to interview them.
So Mr. Wernick said that you personally interviewed him. That's correct?
Yes.
Is that true for the other 6 people?
Yes, it is. Throughout my tenure, I was present every time anybody was interviewed. I was present. This was Madame Dawson's practice as well. I simply followed the same practice.
How many investigators, did you have that worked on the file?
We had 1 investigator, and we had 1 lawyer, Michael, who is here today, who played an extended role on this one, because Madame Richard was excluded from the file right on day 1. I gave clear instructions that Martine Richard was not to be involved in this investigation. So it was Marie-Josée Smith, Michael Aquilino, and I, period.
Is Ms. Smith still employed in the office? She is. You've said that in interviews following your retirement, sir, that your investigator has a set, or that you in the process used 49 questions. Is that the right number? It was a list of 49 questions?
I'm sorry, Mr. Chair, I have no recollection whatsoever. I don't know. We don't know. I have no idea where this comes from. I don't.
Okay. If I recall correctly, I think it was in a podcast where you talked about your interview process, maybe with the Hill Times.
It's not possible, Mr. Chair, because we don't have a standard interview format.
Okay.
Each time the way it works, each time we have a witness, Marie-Josée prepares a draft, Michael reviews it, I review it, and we follow the script, except that the commissioner is there to add, to emphasize certain things, to ask questions that come up because of earlier answers and so on and so forth.
Okay.
So there's no
form.
preordained format whatsoever.
In the case of the Trudeau 2 report, were you fully able to discharge your investigatory duties defined or provided for by the Act?
No, as I said so in the report, Mr. Chairman. We tried to obtain further documents that were covered by the Cabinet Confidences Convention, and we failed in doing so. So therefore, but I thought that we had nevertheless enough material to come to a conclusion, to a finding. That's why I did proceed absent the documents that were missing, that we still don't know what they contain.
Right. And that finding was a finding that, of a contravention, that the Conflict of Interest Act had been broken by Mr.
Section
Trudeau.
9 of the Conflict of Interest Act there was a contravention, as we refer to them, to Section 9 of the Act, which was the scope of the investigation. I decided on my own volition, in light of the media and what was being said elsewhere, to launch an investigation on February 8, 2019. The scope was Section 9,
Okay.
and I did find a contravention to Section 9.
Thank you very much, sir. Commissioner, are you investigating any board members at Sustainable Development Technologies Canada?
Talking to me?
Yes, sir.
I'm sorry. I thought you were still dealing with
I just
mine.
changed gears.
Can you
with
repeat your question, please?
With my last minute, a couple quick questions for you. Are you investigating any board members at Sustainable Development Technologies Canada?
Yes,
How many?
2.
And have you launched any investigations of your own accord, or only files that have been referred to you?
No, I have only launched investigation at the request of I think members of parliament or maybe the public, I don't know, but not on my own.
Have you interviewed relevant people in those cases at this point?
Mario explained to you the process, and that's exactly what we're following to, where we decide who has to be interviewed. We make a set of questions. The questions are being posed by the investigator. I'm there, I'm present. I may ask additional question or clarification if required.
So I have two quick questions in my last 15
Very
seconds.
quick.
Have you received access to all of the documents that you've requested? And when can Parliament expect a return on those reports, sir?
Yes, I have received all the documents I've asked for. We are interviewing a few more witnesses, and then as soon as we can, will issue a report. Obviously, I'm fully aware that time is of the essence. These things shouldn't drag out too long, both for the public but also for the person being investigated.
Yes, sir.
So we will do it with due dispatch.
Thank you, sir. Ms. Damoff for 6. Go ahead, please.
Thanks, Chair. Thanks to our witnesses for being with us here today. Mr. Dion, thank you for coming to the committee to talk about a report that was done a number of years ago. I have some questions for you on Section 49(1) of the Act, where it talks about suspending your investigation. I'm sure you're familiar with it, but just for those that aren't, where you need to suspend an investigation when the commissioner believes on reasonable grounds that the public office holder or former public office holder has committed an offense under an act of Parliament. And there's more to it, but I'll leave it at that. And I know when you testified in 2022 about whether or not you would hesitate to turn something over to the RCMP, you responded that it was a mandatory provision, so not a choice the commissioner has, that it's an obligation to refer it to a police force that has jurisdiction. So you're always mindful of that in your investigation. So I'm just wondering if you could talk a little bit about this report and whether you referred it to the RCMP, I guess is the first question.
In any investigation, Section 49 is always present to mind because facts evolve. These investigations take several months. So in relation to the Trudeau 2 report, Michael Aquilino is with me. did a preliminary analysis of whether there were reasonable grounds to believe an offense to another act of Parliament was involved, and came to the conclusion that there wasn't such a situation. But throughout the investigation, we always have the question present on our mind because it's an absolute duty to do that. So at no point did I feel that I had reasonable grounds to believe that the Prime Minister had committed an offense to any other statute. Therefore, I did not refer the matter to the RCMP.
Thank you very much. I wonder if you could talk a little bit, and perhaps we could get our current commissioner to comment on this as well. The importance of independence of both the RCMP and the Commissioner of Ethics and Conflict of Interest.
Okay, well, as you appreciate, what is vested in the commissioner is a lot of discussion to look at the various situations that he faces and decide what to proceed. 49 is a perfect example of that. The commissioner independently investigates something. If there's something where he has reasonable grounds to believe a criminal offense may have been committed, he stops right away and he refers it to the RCMP. And that's because he is independent, but so is the RCMP, and obviously criminal things are more important than conflict of interest. So if there's a criminal one, it has to be first done. Once if the RCMP decides they do not want to investigate, or they investigate and conclude, then we continue with the conflict of interest. But the two should not interfere with each other. We both have a mandate. We both have to exercise it to the best of our ability. And the statute specifically vests persons' powers for criminal prosecutions, the RCMP, and for conflict of interest in us.
Thank you. And just before I go to Mr. Dion on the same question, I just wondered if you could comment on the importance of your office as well as the RCMP being independent from interference by politicians.
Yeah, well, if the whole system is set up such way that we are independent, we are not partisan, we are not influenced by any consideration other than what is the mandate. I, in my case, make sure there is no conflict of interest in the RCMP to make sure there are no criminal activities. That decision should be made objectively on the basis of fact and without any influence of connections, partisanship, or anything else.
Thank you. Mr. Dion, I wonder if you could comment on that.
I've said many times during my tenure that it is clear that Parliament intended that the Commissioner be tasked with the mandate of that Conrad has just described, in the conflict of interest sphere, and that the Commissioner was a person who government tried to ensure had some judgment when they first appoint him or her. And basically, I felt throughout those 5 years that I felt completely independent, nonpartisan. There was no attempt whatsoever at any point by anyone to try to influence in an inappropriate manner, the work of the Commissioner. And I'm sure that should continue to be the case in the future because it's one of the safeguards that we have in our democracy, and everybody seems to understand that.
And do you want to comment on the independence of the RCMP as well?
Frankly, no, I don't think I'm qualified to do that because I have not read the RCMP Act in the last 30 years, so it's hard for me to
Okay,
imagine.
that's fair. That's fair. Well, thank you both for being here today. We appreciate, well, all three of you actually for being here today. And Chair, I know I only have about 10 seconds left, so I'll give it back to you.
Okay, thank you, Ms. Damoff. Monsieur Villemure, pour 6 minutes, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. Thank you to our witnesses for appearing here today. Mr. Dion, you conducted this investigation, so I have 3 questions. Yes or no questions drawn from your report. Mr. Trudeau, did he try to influence Judy Wilson-Raybould? Obviously, the report concludes that Mr. Trudeau directly or through intermediaries tried on several occasions to influence the Minister of Justice. Did Trudeau tried to influence the management of SCNC leveling. The pressures that were exercised on the former Minister of Justice showed that and the behavior of management of SNC leveling showed that they preferred a settlement rather than rather than a case before the law. Did Mr. Trudeau use his influence, therefore, to influence her? Well, the contravention is the use of his office in view of influencing somebody in an irregular manner. So you describe the concept of irregular, and you define 4 areas where there was a use of this influence compared to public interest, and you observe that there was a contravention. Yes, there was a contravention to Section 9 directly. And sometimes it's often said that we should base ourselves on facts in order to conduct an investigation. The facts at your disposal, were they enough to draw that conclusion? I think we took about 40 pages to 40 detailed pages to detail the persons involved, what they did, and the facts which underpin my conclusion is what you'd find in the first 40 pages of the report. Well, I read it back in the day, and I read it again recently, and the Office of the Prime Minister's privacy, and I'll come back to RCMP's statement, which said that privacy, does it vary based on the context? And you responded by saying that there are moments when this discretion was less airtight. And do you think that
Come on in
this
if you
notion
want.
is something that can be applied?
The camera's facing the other way.
The camera's facing the other way?
Oh, my.
Ah, ouais, bon.
Okay.
Donc, je peux répondre parce que j'ai compris votre question.
I can address your question because I understood it, Mr. Chair. I will try to address the question. There's a certain familiarity with the use of secrecy and confidentiality, and we talked about this. And secondly, I worked at the Privy Council office. I was in charge of the unit that was in charge of issues regarding confidentiality at the office for a year. And when we discussed the Trudeau 2 report, when we were confronted with 6 or 9, I don't remember the exact number, but a number of witnesses who said, I will send you all the documents that you requested, except for those that are covered based on the that notion in the cabinet. I was a bit surprised because the law on conflict of interest says that the commissioner should benefit from this particular situation. And we wrote to the clerk of the Privy Council, Mr. Schubert, to insist to have more than what the Act allowed Ms. Remble to share. And we were still denied access to those documents. And then I had to determine whether I had enough documents to continue. And I reflected on the possibility of going to federal court to contest the clerk's decision. All through my 43-year career, I always paid attention to the use of public data and considered that it was not necessary to spend 3 years and $2 million to establish that I will have or not have access to these documents. So we continued in the absence of those documents. When RCMP decided to investigate on the same topic following the publication of your report, were you surprised by the conclusions of RCMP? No, I wasn't surprised, but it's not founded on any grounds. So they did not equally have access to those documents, and they had the same conclusion as yourself. And this is something that's within the realm of possibility, right? If we're talking of criminal activity or contraventions to the code from a criminal point. So they talked about contravention to justice, and it's not the same thing. This week we received Mr. Warnick, who came and tried to not say anything to committee. Now, with your interrogations, Mr. Warnick, was he cooperative? Did he cooperate? Did he provide interesting details? Because we have the verbatim of the conversations, and Mr. Warnick did not want to acknowledge those words. And I mean, I don't remember everything, but Mr. Wilson Rainbow was told not to use the legal instruments at her disposal. And I'm trying to read between the lines here. Now, during his interrogation, was he more cooperative? Mr. Warnick was addressing our questions. I know Mr. Warnick because we worked together at the Privy Council office, and his answers were brief. That's Mr. Warnick. It's in his nature. And yeah, we understood that he's a man of few words, and I think some people do not understand the mandate of the Ethics Commissioner, Mr. Van Dijk. What do you think about this? The Commissioner of RCMP seems not to properly understand your mandate, where it begins and where it ends. And maybe he needs a small training in that field. Like my predecessor mentioned, the mandate is clear. And the question that we have to ask is whether there are documents that are necessary. And in this case, we're talking about the confidence of the Privy Council. And Mr. Jim made a general comment on not really understanding the role of the commissioner, not in the report, but the general role of the commissioner. And I think maybe you would want to clarify that with us, because it would help us better understand your role. I was a bit surprised to hear that question. Thank you, Mr. Villemaire. I allowed you a bit more time because I didn't want to interrupt you, but thank you.
Directly at you, you have 6 minutes. Go ahead.
I do appreciate that. Dealing with some technical difficulties on my end with Adobe, but that's another story with those licenses. I'm trying to, for me at the crux of this, and one of the things I've been really stuck with is the Convention of Cabinet Confidence and the issue of the position of the government, particularly this government, I would say, that being both the client and the solicitor, that they have, basically that client solicitor privilege, and then the broader stroke of cabinet confidence as a convention. And I'm wondering to the members, and they can each answer, their thoughts on the effectiveness of that, and whether or not for issues that require greater scrutiny, third, nonpartisan oversight, that through their offices, having access to some of those key documents and information would help provide a better check and balance to the PMO or the Privy Council.
The Act is quite clear. We have access to those documents if we require them and we need them. Obviously, in each case, if there is a refusal to give some or part of documents, we look at them, are they essential to the investigations or not? If they are, we will push it to the ultimate, and as Mario mentioned, we can always go to the federal court if we think it's so germane and so central to an issue that has. But most of the time, you work this out, you understand there's some reluctance, you make sure you get the documents that you need in order to reach your decision. Your decision being, was there a breach of a conflict of interest or not? And that's, in the past has always been worked out, and I'm pretty sure it will be in the future. That being said, the law is quite clear. If we need access to these documents, we can get it. Mario, you want to add something?
I will just add that's precisely what I did. I did assess whether, with the documents and the refusal to provide further documents, I had enough to proceed, and I concluded I did. And there were several instances during my 5 years where Michael and other lawyers who work at the office were able to gain access to cabinet confidences in a very practical, informal way. This was actually the first time that we were opposed with a written no. You will not gain access to additional documents.
As it relates,
the problem with cabinet confidences is that you don't know what you don't have. So you have no idea what you're not seeing. And but I determined I had enough to do Section 9, so I proceeded.
And I think, like for me, in listening to the testimony of the RCMP, and when I hear things that, investigations cannot proceed based on the information that is available, do you believe, and I'll start with Mr. von Finkelstein, do you believe that the RCMP, particularly related to criminal matters, should have access to cabinet confidence documents in order to adequately provide oversight?
I think you should put that question to the RCMP rather than me.
Okay.
Or, to see
if you don't want to answer,
they feel they have enough. Obviously, nobody should be able to hide behind criminal acts, and the investigators should have access to all the facts necessary to determine whether a crime has been committed or not.
Thank you. Stories were posted this morning about additional information as it relates to the Prime Minister's trip to Jamaica. And in particular, I note the way in which the information is coming out in trickles, dribs and drabs. First, there's a bit of a denial, and then there's a bit of a deflection, and then there's a dig in, and then we find that there's more and more information. So, in light of the various Trudeau reports, and in light of some of these discrepancies, do you believe that amendments to the Conflict of Interest Act should provide, particularly to the office holders and to the Prime Minister, what do you suggest that we do to tighten that up so that the perception of a conflict and the real conflict are dealt with in a seriousness that helps kind of restore the public confidence and trust?
You used the word perception right now, and I think it's very important to do that. Unfortunately, the Act deals with conflict of interest. There is no apparent or a conflict of interest provision. There is in the code for the members of Parliament, as you know, for House of Commons, as you know. That's a question that you could put, and that is not only a real conflict, but a perception of or apparent conflict of interest. Another one, since you're talking about the Jamaica trip, is, for instance, should there be a ceiling on gifts? Right now there's a complete exception for gifts from a friend. You could say, well, that's fine, but if the gift is too large, it may create the wrong appearance, and maybe we should have a monetary limit on it.
I really deeply appreciate that, because I know that there was a past commentary that, well, if they're wealthy, why shouldn't wealthy people be able to give wealthy gifts? But I think to the average person watching, the average person struggling in this economy, that extravagant gifts in the tens of thousands of dollars, $80,000 plus in these luxury settings, it begs back to my earlier points about sponsored travel and other things, that in a time with conspiracy theories and distrust in government, that there needs to be that cap. So I'm glad to hear that reflected in the testimony today. Thank you. Those are my questions.
Okay, thank you, Mr. Green. That concludes our first round of questioning. We've got 5-minute rounds followed by 2.5, 2.5. And just a reminder to the committee, I do want to leave some time because Mr. Villemure wants to bring up an issue in front of the committee that should not take too much time. Mr. Brock, for 5 minutes, go ahead.
Thank you, Chair. And thank you to the witnesses for your attendance today on this important study. I'm going to read to you a portion of a mandate letter that Justin Trudeau supplied to one of his ministers, Minister Anand. Talked about raising the bar on openness, effectiveness, and transparency in government. Says it also means humility and continuing to acknowledge mistakes when we make them. Canadians do not expect us to be perfect. They expect us to be diligent, honest, open, and sincere in our efforts to serve the public interest. Yet February 7, 2019, the Globe and Mail cites unnamed sources, reports that Justin Trudeau and his aides attempted to pressure Jody Wilson-Raybould while she was AG to intervene in the prosecution of SNC, and that exasperation and her lack of cooperation was one reason for shuffling her out of the justice portfolio. Justin Trudeau, when pressed by reporters at some event in Canada, looked Canadians right in the eye and said the Globe story was false. He lied to Canadians. He ultimately received your report, Mr. Dion. He says, well, he disagrees with some of the findings. He accepts the report and takes responsibility for the mistakes that he made, whatever that means. He didn't elaborate. We all know your conclusions. Your conclusions were well founded. Your conclusions were based on all the evidence that you received. You took it upon yourself, I believe, Mr. Dion, to identify all the relevant witnesses and the evidence that you hoped to be able to discharge your responsibility. Is that correct? And I've totaled 14 individuals that you ultimately either interviewed or received by way of affidavit or some other written documentation. I contrast that to the RCMP. And I can't express how profoundly disappointed I am as a member of Parliament, but as a former officer of the court and a former Crown attorney, of the shipshod way that they conducted this investigation. They only interviewed Jody Wilson-Raybould twice. They interviewed Jessica Prince, her chief of staff. They interviewed Natalie Drouin, deputy attorney general, and nobody else. And when I asked the commissioner not too long ago, why didn't he actually seek out some information from the prime minister himself, the person of interest? They didn't think that they had sufficient grounds to do that. That really disturbs me, sir. I'm not going to be asking you about RCMP decisions, but what I am going to ask you about is when you interviewed Justin Trudeau, was he forthright with you? Did you get the impression he was giving you all the information that you requested? Was he holding anything back?
So I recall the interview vividly. It was long, over 2 hours. Prime Minister was accompanied by a few lawyers. And he did respond to every question we asked. There was no feeling of resistance or trying to indirectly avoid questions. He did provide answers to every question that we had.
Okay. Your standard of referral to the police, I believe you said, is on reasonable grounds. Is that a reasonable ground test? And perhaps to Mr. Is it Aquilino? Is it the same reasonable ground test that law enforcement uses in terms of laying a charge?
I believe so, yes.
Okay. So, and again to Michael and to you, Mr. Dion, we all know that there's two elements to any criminal offense, the actus reus, the mens reus. The actus reus is the act of the pressure exerted, either by Justin Trudeau himself or his aides. The mens rea requires a specific intent. Now, I want to circle back to your report, Mr. Dion, paragraph 284. I'm going to read it out to you. It's very, very, very brief. Here, in contrast, the evidence abundantly shows that Mr. Trudeau knowingly, the operative word, knowingly, emphasis mine, sought to influence Ms. Wilson-Raybould both directly and through the actions of the agents. That's the operative term I look for as a former Crown attorney. So I'd like to know your opinion, perhaps Mr. Aquilino, in terms of the reasonable ground test. Did that not give you the ability to make that referral based on that finding?
I think that those are legal issues. Criminal side, the Conflict of Interest Act, knowingly in the context does not necessarily mean knowingly for the mens rea purposes under the criminal code. That's a legal issue. So
Well, I disagree respectfully. I think it knowingly means the same thing. It's an intentional act to do something knowingly, as opposed to innocently, accidentally. Knowingly is purposeful.
Sorry.
Sorry.
You're gonna have another opportunity to ask
Thank you.
questions if you like. Mr. Housefather, go ahead, please.
Thank you very much, Mr. Chair. Gentlemen, thank you for being here today. Mr. Dion, I have a question for you, a little bit of an esoteric one. In Section 9 of the Act, it reads, no public office holder should use his or her position as a public office holder to seek to influence the decision of another person, clear, so as to further the public office holder's private interest, clear, that makes all kinds of sense, or those of the public office holder's relatives or friends, makes lots of sense. But then it goes on to add or to improperly further another person's private interests, thus lumping in the other person to something that would directly benefit the public office holder or his family or friends or her family or friends in the same breath. Do you believe it should be the same, the wording should be equivalent in this case? And I guess I'll come to it from the perspective of a public office holder is frequently, as you know, seeking to push government to deliver funding or grants to companies in their riding. They're not doing it for themselves; they're doing it for the benefit of their constituent, their community. How is that equivalent? Because in this case, we're talking about Mr. Trudeau and SNC-Lavalin. Nobody is alleging Trudeau has any private interest in SNC-Lavalin, or that he's benefiting personally, financially from anything that goes to SNC-Lavalin. How are these concepts intertwined? And would it be better if there was one language that related to your own personal benefit and another clause that dealt with the improper dealings related to a third party. I don't know if you understand the question, but it's been in my mind for a bit.
I do understand the question. I've never actually asked myself the question, so therefore I cannot offer any improvised answer. Section 9 was the subject of parliamentary debate. It was part of the Accountability Act. I assume the crafters knew what they were doing, and my role was to implement Section 9 as it exists. I don't have a view, I'm sorry, at this point, because I've never thought about it.
Okay, I understand. So then, can we get... Oh, of course, Mr. Van Finkel, please.
Overlooking the word improperly. This section deals, first of all, influence anything further, somebody's private interests or the presence of a friends, etc. And then when you're talking about unrelated third parties, it is improperly furthering it. So, you know, you're obviously part of your job is to further, like, the interests of your constituents, etc. But do it properly, don't do it improperly. And that's the distinction in the Act.
And there are reports from the office going back several years that deal with that. It's only when you go out of outside accepted avenues that it becomes improper.
No, and I understand. I've read the Trudeau 2 report where you do a detailed analysis of how you arrive at the idea that it was improper in terms of crossing the Shawcross Doctrine. I do understand that. I was just wondering, because even though it's improper, one of them relates to your own personal interest and your own benefit, and the other relates to the benefit to a third party. And I just thought it might be...
Although, Mr. Chair, I'll add that in the document, we do indicate that the Prime Minister or one of his assistants, Mathieu Bouchard, mentioned that there was an election. There will be an election one day. And it's important to win an election. And this matter could have an impact on Mr. Trudeau's electability in Papineau. That was mentioned by that witness. So maybe there was also some interest on the part of the Prime Minister.
Okay, I'm reading your report and I understand. I'm trying to then get to another question in terms of the entire interactions here. Was it because Ms. Wilson-Raybould was the Attorney General in this capacity that you looked at it in a different way than if it had been a different minister? For example, if she had been acting in her capacity as Minister of Justice, because of the very different rules related to the Attorney General?
Yeah, the central issue of the Shawcross doctrine, of course, was related to her role as Attorney General. It played a very important role.
So if the same interactions had happened, because again, we don't know if anybody in the Prime Minister's office at that time understood the Shawcross Doctrine, if they really understood that there should be a difference in the way they treated the Attorney General versus another cabinet minister. If this had been, for example, the Minister of Health, and it had been a decision related to health care, would you have treated it in the same way? Would there have been that impropriety?
Again, it's hypothetical. I don't know if there's any doctrine that exists in the sphere of health, so I frankly don't have any idea. But I would like to add that Ms. Wilson-Raybould on several occasions tried to explain the very specific nature of her role as Attorney General to those who were trying to influence her. So they had an opportunity to reflect on that. Because that's one of the first things you learn in criminal law, the independence of the prosecution. And I know that when I was at the Department of Justice, this was sacred. So she tried to explain that, but maybe they didn't understand. Okay.
Yes, you are. Thank you. Thank you, Mr. Dion. Monsieur Villemure pour 2 minutes.
Mr. Villemure for 2 minutes and a half. I'll ask the same question to both witnesses, knowing that I have 2.5 minutes. Now, would you consider over your different mandates that involved cabinet confidence that we should better clarify the circumstances under which we should have access to documents, or whether, as part of an investigation of this nature involving a minister or a prime minister, that there should be a special procedure that would allow you to be able to shed light and maybe even more have a different judgment, because do you think that this would allow you to ensure that you have everything available? Because I have a feeling from previous witnesses that they experienced problems with the cabinet confidence, whereas I believe that it is a good thing in itself. But do you think that there will be, we need to make changes there, Mr. Dion? I think it's possible to handle every situation within the current or the given legal framework. And so I think it's enough to address the needs, arising needs. And this was the first time that there was a collision since the creation of the office 18 years ago. So it's not worth the 3 years and 2 millions. Exactly. I agree with my predecessor. It is not an issue, as we mentioned, and I think that we always have the possibility to go before the court if we think we need further documents. We are not talking here about criminal activity. We're talking about conflict of interest, and we have many other ways of going about this. So you drafted the Trudeau 1, 2, and 3 reports. Trudeau 1 was Miss Dawson, so 2 and 3 in your case. And from outside, as I was looking at it, I would see certain trends reemerge. I was seeing some sort of laissez-faire attitude with regard to discipline. What did you think about this situation? I think I addressed this issue the last time I appeared when I was a commissioner, and I wished that certain members of government should take the question more seriously. Some take it seriously, others a bit less. And that was my perception a year ago. Maybe things have evolved in a positive direction since then. My successor would tell you. So you said that some members acting in a very
Mr. Green, 2.5. Go ahead.
I'm sorry, there's always a bit of a delay on the translation side, so I can't hear it get picked up. Thank you very much. I have a question for Mr. Dion because it's, our committee's prerogative to try to provide recommendations, hopefully get something out of these studies. And so I'm wondering for you, in retrospect now, what lessons might have been learned from your involvement in the SNC-Lavalin affair?
Not much. I think we had the tools. I was able to launch an investigation very quickly after the facts emerged, the allegations emerged, I should say. So there's not much that need to be changed, and nothing I can think of at this point in time that relates to the conduct of investigations. I think it works well the way it is now. And there's a margin of maneuver that the commissioner needs, and the commissioner has the margin of maneuver, and I would leave it as that for the time being.
So there's no, if the same situation were to occur again, there's no, notwithstanding the fact that the cabinet confidence issue was still present, there's no different approaches that you may have taken to try to get more information?
When people are interviewed, that's how we refer to those interviews. They are under oath. They're placed under oath. There is a stenographer present. There's a transcript. So it's a pretty solemn event. People take it seriously, answer the questions. We use the transcripts extensively in preparing the reports. So I think we have enough formality as it is to be able to do our work. My successor has enough powers to do the work, in my opinion. He may differ, I don't know.
So if there's enough, that's great. If we were to look at improving the standard, again, going back to the notion of cabinet confidence, could there be anything that we could contemplate as a committee that might trigger an automatic disclosure for certain levels? Or are you simply here in your testimony today saying everything's fine, nothing to see here, should this happen again, we can expect the same kind of outcomes?
The one thing I haven't said is it would be hard to create such a list because there is a myriad of possible scenarios. It's always dangerous to try to put an exhaustive list of situations. That's why I think with the flexible approach, what I did with Mr. Shugart was my approach. Try to impose some, if you wish, pressure on getting more documents. I did not know until I received the reply what the reply would be. Michael can attest to that. because I don't know what was in those documents that I didn't get to see. So the answer was no, and then we accepted the answer. It's hard to imagine a statute could change that.
Hey,
Okay.
merci.
Thank you so
Mr.
much.
Dion.
Thank you for the extra time, Mr. Chair.
Yeah, no worries, Mr. Green. We're going to go 4 and 4. I'd already predetermined that in advance of Mr. Green speaking. Mr. Kirk and then Mr. Baines for 4 minutes. On va donner un peu de temps pour M. Villemire à la fin.
We'll allow some time for Mr. Villemire at the end of the session.
Thanks very much, and appreciate the testimony here today. Mr. Aquilino, Mr. Brock had asked a question about the Prime Minister having, quote, knowingly influenced former Justice Minister and Attorney General Jody Wilson-Raybould, and that term knowingly. And it's my understanding that in civil and criminal law, it's a fairly low threshold, but it is interpreted the same. And I'm just wanting, if I could, Mr. Aquilino, your interpretation of that threshold and whether or not that threshold was in fact met, and your interpretation of the events that took place related to that question around him having knowingly influenced.
Sure. So when you apply the facts of what transpired here to the wording of the offense, so 139 sub 2, you have to apply the knowingly standard to the act of obstructing, perverting, or defeating the course of justice. And what the case law says that it takes more than a mere moral lapse or an ethical lapse of judgment. It takes something, an additional step, so a corrupt intent, a criminal intent. And this is where we had difficulty in establishing that intent.
So when it comes to the establishment of that intent, at the time, and I was not elected at the time when I followed this, both the breaking story in the Globe and Mail and what transpired, the damning testimony that Jody Wilson-Raybould had brought forward at committee, and just the whole, it was extraordinary to watch. I was very troubled at the time how narrow the constraints were on the evidence that could be obtained both by the office of the Ethics Commissioner, but also in light of that to the Justice Committee and presumably the impacts that had in relation to the RCMP being able to get to the bottom of exactly what you've referred to about knowing what that intent is. So could having more evidence, understanding what the bigger context is, and certainly you don't know what you don't know, but if there was more information available, could that have influenced and led to you, the RCMP, and others coming to a different conclusion? Mr. Dion?
Purely speculative. So it's impossible to answer your question. Of course it could, or maybe it couldn't. I don't know.
So it could have, and I think that's the question. Why were the constraints so tight? And certainly that's an outstanding question that remains, and an incredible disappointment that there was not a willingness for the government to be more transparent, and it leads one to ask the question about what is there to hide. Now, I do want to ask another question, because yesterday the Liberals tabled a amendment to the Canada Elections Act. And in that, on page 2, there's a very interesting change to the election date. And as the public, I'm sure, is very aware, MPs qualify for a pension after 6 years of service. The election was planned to be held on October 20th of 2025. That would have been 1 day short for MPs elected in 2019 to qualify for their pension. And while Conservatives are calling for an election immediately, I'm just wondering if that delay in the page 2 of this act, if that would be a conflict of interest for MPs to basically vote on something that would be the difference between them either qualifying or not qualifying for their pension.
Very, very quick response on that, please. Very quick.
You as MPs have the power, make the rules for yourself, including your code of conduct, and also when elections are held, etc. That's not a conflict of interest. It's something that you are charged. It's a duty one would expect you do it in the public interest and not in your personal interest.
Thank you.
But that's
Would there be a
That's enough time.
could there be a perceived conflict in that?
No, Mr. Kirk, I'm sorry, I'm over time. I think the commissioner answered the question. Go ahead, Mr. Baines, 4 minutes. I had Mr. Baines, Ms. Khalid, go ahead, please, 4 minutes.
Thank you, Chair. And just to clarify, I know that my colleague asked this question about nefariousness and perhaps conspiracy theories going down that rabbit hole, but October 20th of 2025 is the day of Diwali, which many hundreds of thousands of Hindu Canadians celebrate. So I think it's good for us to be. Sorry, Mr. Brock, are you interrupting my time here? Oh, okay. I'm glad that you are. Thank you so much. So just wanted to clarify that and put that on the record. Can we, Mr. Aquilino, can we just talk about sanctions? What kind of sanctions do you feel would be fair, equitable, and enforceable? And do you think that the current sanctions are enough as it stands right now?
Yeah, point out Mr. Aquilino is here in order to help Mr. Dion recall the facts regarding Trudeau II report. He's not here as a witness to give to speak.
Then perhaps to Mr. Dion then.
I've expressed the view in the past that maybe the issue of penalties should be looked at. There is an absence of direct penalty in relation to the Act. It should be looked at. In terms of the credibility of the system, it would help if there was a possible sanction to be recommended by the commissioner, but to be imposed potentially by the House or by another upper authority, if you wish. So that's been my view throughout. I don't know what my successor thinks of that, but that was my
Thank you. And to that, Mr. von Finkenstein, are you considering reviewing those sanctions at all?
I have in the job now literally 1 month, so it's busy. It's a temporary period, 7 months, so it's a bit early to. Clearly, when the chairman congratulated me on appointment and asked for, do I have any views towards improving the Act? And I wrote him yes, and undoubtedly there will be some, and I will express it at that point in time. Right now, as you know, the main penalty for breaching the Act is that you get certified that your reputation is not what you're holding it out to be, that you do not understand your job and you acted in conflict. And that's a pretty bad penalty for an elected official. Should it be supplemented by these suggestions along what Mario suggested? It's something I think I would like to study a bit more in detail before making any statement on it.
Thank you. I have one more question for you. I know that members opposite have been directing and demanding that you haven't really done your job effectively on this specific case and many others. Can you talk to us about the importance of independence of the work that you do, the work that the RCMP does, just the same that you wouldn't be directed by political officials? Would you then go and direct RCMPs as to how they conduct their investigations?
I'm sorry. I mean, as you know, I'm not a public servant. I report to the Speaker of the House, etc. So that's to insulate me from political. The Act is quite clear. Decisions are to be made on the merits, and decisions are made public. And they're made public immediately, as we do. Like, for instance, in Trudeau II, at the same day that the report came out, it was also published. So there can no opportunity to hide it. So we're trying to do the whole scheme is to be as public and as open and as fair as possible. Can it be improved? Sure, everything can be improved, but I mean, there's no glaring omission or fault right now that I'm aware of. As far as the RCMP is, you should ask them, not me, as to whether they feel they need more independence or not.
Thank you, Commissioner. Thank you, Ms. Khalid, and certainly we appreciate the independence of the office as it reports to Parliament. Commissioner, I want to thank you on behalf of the committee for being here today, and again, congratulate you on your appointment. I, as the committee chair, have the utmost confidence in your ability to do your job independently and effectively, and I look forward to continuing to work with you. Mr. Dion, again, thank you for your service to our nation and retirement. You seem to come back every once in a while at the request of the committee, and I appreciate you taking the time to do that when you could be someplace else. But thank you, Mr. Dion, and Mr. Aquilino. Thank you for your time today. Je vais donner la parole à Monsieur
I will now like to turn it to Mr. Villeneuve for an additional item which he would like to discuss with the committee, and just to inform Mr. Villeneuve that we are preparing an in-camera report, so we cannot talk about the report, but you have something to share with the committee, and maybe the committee would be in agreement with you. Well, over to you. We conducted the study on social media. The report is currently being drafted, but for many things, sometimes the context may change. And last week, we learned that the the Department of Innovation launched a national scrutiny exercise on TikTok, and maybe TikTok knew, maybe they didn't know. We have no idea, but the picture that was painted was far from something that looks like a national security study. And recently, TikTok was qualified as a digital fentanyl in the 21st century. We've heard all sorts of things, but the fact that a Canadian minister requested a national security study, I would want to doubt the validity of this report. Maybe there's a possibility of us issuing a warning or mentioning that this report should be completely cancelled and that we don't publish it. Now, I would like to throw the question to the group here, because I believe that if we don't have a clear action with regard to this report, our report may be ridiculous, so to speak.
Today, I just warning the committee now, just based on the services that are available with us. But I will say that I am in agreement with Mr. Villemure that we put the report on the shelf for now, pending the results of a national security review. And then if at that time we need to reopen the report, we can do that and have witnesses reappear if we need to, because there may be things that we might add to the report. My concern, frankly, is that we're going to make recommendations that are contrary to what the National Security Review provides for, and are the results of the National Security Review, and it's going to look pretty foolish on our part to make these recommendations if they are in fact contrary or contradict what the National Security Review proposes. So I don't think there's any harm in holding on to dealing with this report until such time as this review comes forward. And the other thing that I would say too is that there was no indication at all during the time of our study that this National Security Review was going on until it was made public last week. So go ahead, Ms. Khalid.
Chair, do we know what the timeline looks like for the NCERA to come back?
No, but I am going to take it upon myself on behalf of the committee to find out, okay?
Can we then table this question as to whether we're going to be shelving this report until we figure out what the timelines look like? To me, it makes more sense if we're able to bring in TikTok maybe for one more time, to bring in whatever relevant witnesses for one more time to address these concerns and then include that within the context of the report, rather than just shelving it for an indefinite period of time.
Okay, so here, this was my plan, just so that the committee knows, or the plan for the committee. When we come back from the 2-week constituency period, we were going to start the report the second, I think it's the second day of the report in camera. So what I can do is I can schedule committee business at that time to provide an update to the committee, and then we can carry on with this discussion later, if that's okay with the committee, until I find out information as far as the timelines of what the National Security Review is. Would that be acceptable to committee? Okay, and that covers what you're asking for. Okay, are we all okay with that? Mr. Barrett, you good? Monsieur Vale, Mr. Green, sorry. Okay, thank you. All right. Merci, Monsieur Villemure. That concludes.
Thank you, Mr. Villemure.
Hope you have an effective couple of weeks in your constituencies, and look forward to seeing everybody when we come back. And again, condolences to the Mulrooney family as they head into a difficult period on Saturday in the celebration of the former Prime Minister's life in Montreal. Thank you. Meeting's adjourned.